Right now to our next story, where a Christian healthcare worker, that's Rhoda Jitao, who has been detained since May 2022 on charges of blasphemy, lost her legal bid to regain freedom. On Monday, the High Court in Bauchi State rejected a no-case submission request brought by the defense. Rhoda's attorneys had hoped that the charges brought against her by the Bauchi authorities would be dismissed, paving the way for her release from jail. But the court ruled in favor of the prosecution that Jitao has a case to answer, and her legal team must now present the case for the defense. Jitao faces charges of inciting public disturbance, exciting contempt of religious creed, and cyber stalking. The contempt charge is the civil equivalent of blasphemy under Islamic Sharia law. Arise analyst Dr. Sam Amadi joins this conversation now. It's great to have you. A very warm welcome to Newsday today. We're going to get straight into this conversation, Dr. Sam Amadi. So this case has been characterized by adjournments and postponements. Is this an indication that there may be something untoward happening through this process?
Well, maybe, and again, the way that prosecution and courts, whether it's area court, Sharia court, or regular magistrate high court, the way they operate sometimes does not provide clear transparency for, administration of justice. The hallmark of justice is openness. So some of those processes may be a little bit, may raise concerns. But again, the key issue here should be why in the 21st century anybody should be facing trial for what amounts to as blasphemy. We know that the penal code, those offenses may remain or something look like it, but more so in the Sharia law. And this has been the problem. When we get to this point, 2 points are made. Some people say, well, first, the constitutionality of trials that are based on religious doctrine or text. And again, people say maybe inciting or speaking against religion, whichever one, ought to be, disproved. But I take the view that the notion of citizenship and what it means for criminal justice is that there should be no criminal offenses on the basis of religion. And this has been the status of constitutional law, even in northern Nigeria in the First Republic, when you could say that we have regional governments and the religious leaders were very, very much in control. I remember very well in 1957, a high-level panel committee for northern Nigeria made up of the chief imam of Sudan and India, Pakistan, Nigeria, and Professor Anderson of University of London, the expert in African law. The committee recommended before independence that Nigeria should not have criminal Sharia as part of its law. And that gave rise to the constitutional provision that still exists that says nobody should be prosecuted for an offense that's not written in the law. This was the case up until 2000 when Governor Yerima instituted the Sharia criminal court and the criminal system, basically overruling the Constitution. Because what that therefore means is that you now have not just the normal Sharia law for custody, for marriages, personal law, which is always available even in some Europe, but now you have a public Sharia which deals with criminalizing behavior on the basis of religious faith. Now, the problem is that this flies in the face of the constitutional guarantee to not just opinion, to beliefs, to ideas, freedom, and again, the freedom to change them. So even when you say that these courts are applied to only Muslims, the problem is that Nigerian citizens have a right at any time to change their religion for any reason or for no reason. And so it's constitutionally suspect at most that you can't have a Sharia criminal law in a democracy like our own that has a constitutional guarantee of secularity, constitutional guarantee of freedom of religion, belief, and opinion and conscience. We've also seen a theist who was tried similarly in northern Nigeria, one of the states in Kano specifically, for spreading lack of belief in God. So the question is, when will our criminal justice system protect citizens from mistrial, from being prosecuted, whether Christian, Muslim, atheist, traditional religion, or worshippers, or whatever, from being tried for clearly religious criminal offenses. I think that's really the issue here. And the fact that Rhoda is presumably Christian, or so they said, it raises a second level dimension. And we see just even in Abuja here, FCT, one of my junior colleagues in my office, documented cases of persons being arraigned before what they call area court, but basically courts presided by clerics and Islamic courts, or Sharia courts for that matter, and being tried for maybe disorderly conduct, and these persons are not Muslims, but proceeded against in this Sharia court. So there is documented evidence of the records of these violations of due process of administration of justice, and it's surprising why it has not received strong focus from the Attorney General, from the Chief Justice of Nigeria, and from the government, the presidency itself, because basically this is real heinous violation of constitutional rights of Nigerians. The basis of our democracy is actually the protection of opinion, beliefs, religious belief, or even lack of it. And therefore, nobody should ever be tried for anything. Blasphemy is a religious offense and has no, shouldn't have any recognition in public law. That should be ABC of criminal justice in a secular democracy.
We certainly hear you, Dr. Amadi, and you've made it clear that the provisions of the Constitution frown against what we're seeing, play out in this case. But I'm just wondering, how close are we to it becoming a reality where, there will be not any criminal offenses on the basis of religion? What steps do we need to see for that to become a reality as opposed to an ideal?
Absolutely. I think the first is to take our Constitution seriously, taking Constitution seriously. The Constitution makes that clear. And again, in 2000, really, when this happened, I was a lawyer then, and I went to court at Zamfara. I remember with Olisa Bakoba, we filed a suit against Sharia, against Zamfara High Court. In Guzo, myself, I went there. Of course, they initially said we have no locals. They got local Zamfara Christians who filed the case. And the case went to Court of Appeal, but I left for graduate studies and the matter. Now, Obasanjo's response to what happened in 2000 was to say it's politics. It will sort itself out. Now, what we are learning from history all over the world is that when you see these telltale signs of some disconnection or some dangerous trend, you don't say it will sort itself out. You need to really engage it. So we made that mistake of assuming, well, it was actually brought by politics. The then APP, that became ANPP, lost the presidential election, and they had canvassed on the issue of bringing authentic religious experience in northern Nigeria, and they lost, and they weaponized that and created that as a check against Obasanjo. It was political, but the implication of it was not political. So we now had 12 northern states rapidly get the Sharia criminal law. Now we're at a point where there should be a conversation. Just like you had in 1957, northern Nigeria, they said, no, no, no. In 1959, the London Constitutional Conference, the issue came, we said, let's settle for what we have in Indonesia, we have elsewhere, democracies that have large religious people. What they settled for in Indonesia is that they're not going to have public Sharia. They're going to have personal Sharia. So we said, let's get back. And so in 1959, we settled for that. And that's why you have these Sharia laws exist then for personal issues. Just like you may have Kakariko law, you have other laws. But the secular magistrate courts, area courts, high courts, guided by secular law and legislate against any cultural, customary criminal law. Any law that's not written as an offense by National Assembly or House of Assembly cannot be a criminal law based on the Nigerian Constitution. But like I said, Zamfara undid that constitutional bargain and created an anomaly of a now public law. So we need to go back and restate that basic principle of justice that is in Indonesia in 1999 or more, Muslim society. But they recognize that once you proclaim yourself a democracy, then the minimum is that you allow citizens the right to hold opinion, beliefs, And the minimum is that you take away religion from public issues. And the minimum is that nobody then suffers criminalization on the basis of their religious view. If you don't do that, then you have undermined democracy fundamentally. So the way back is the way we missed the road, is to go back to restate. And maybe the Attorney General can, for example, enter another prosecute. You cannot prosecute citizens, basically. Whether you can't prosecute citizens on the basis of the fact that you think their statement is blasphemous, because it's an open-ended thing. What is blasphemy in a particular region might not be in another. You can even have seemingly innocent. We have hate crime offenses. We have all kinds of criminal laws that prohibit malicious speech, but they are not defined in the name of God or in the name of religious entities. They are defined as speeches that are what we call in political theory, that are publicly accessible. Everybody can say, okay, that speech maybe spread hate speech, hate against people. That speech was false. That speech was reckless. Those are the criteria. So once it becomes blasphemy, then it begins to verge into a disaster. So it can do that. We also, the Court of Appeal many years ago said, in the case of Ono and Nwobodo, Claire, I think Antoine Korada and Nwobodo, where they said even sedition, the offense of sedition, can no longer be possible in Nigeria because of the constitutional guarantee of free speech. They said before we can arraign someone for sedition. So somebody made a statement that the government is seditious, trying to threaten or overthrow government. They said no more, because we have an absolute guarantee of speech and free opinion. Therefore, you can't have sedition as a crime. Again, you can't have blasphemy as a crime in a society that guarantees everybody freedom to hold religious opinion and freedom not to hold, and also guarantees them freedom of belief and opinion. So I think that we've seen these anomalies too many, and it's the job of the Attorney General of the Federation to restate. And then we begin to have the conversation, what kind of society do we really want to be? The society we founded in 1960, or the society that is now founded by default, by error, in Zamfara in 2000. So we have two beginnings now for Nigeria. 1960, there was a clarity consensus that we're going to be that society where religion is a private thing. In 2000, by that very action of Zamfara state, we now become a society where there's now conflict between a democratic constitutional order and a religious order, which is inaugurated in most of northern Nigerian states. So this contradiction is so deep and critical to be resolved, to have really fair chance of equitable criminal justice system.
All right, Dr. Sam Amadi, a Rise Analyst, thank you so much for doing justice to this very sensitive topic. We appreciate your time today.